Today is a special lecture for Grand Rounds. It's the Al Grudzinskas Memorial Lecture named after a beloved faculty member. And to tell you more about Dr. Grudzinskas, it will be Dr. Gina Vincent, who is Professor of Psychiatry and Psychology and co-director of the Law and Psychiatry program. Gina.
Thank you. Thank you, everybody. It's my distinct honor and pleasure to be able to tell you a little bit about Albert Grudzinskas, for those of you who didn't know him, and to introduce our guest speaker today. First, I want to thank Tony and Karen and the Grand Rounds Committee and Dr. Yonkers and the department for continuing this tradition of having this as a biannual event. Albert Grudzinskas was, as it says up there, in the Law and Psychiatry program. He was a faculty who was near and dear to our hearts for many years, and he also was a faculty in iSpark. I'm going to tell you just a little bit about his career. He actually started as a real estate attorney, believe it or not. And then he spent 10 years working at WRCH, helping individuals with commitment, competency, and guardianship hearings. And then he also worked in criminal law for the Worcester DA's office for a while. And that was all before he came here and became on the faculty in the Law and Psychiatry program. While he was a faculty here, he was incredibly prolific. He co-authored several books with Dr. Fabian Saleh, who was one of our postdocs, and many of you probably know him, on sex offender and sex offender treatment. He had over three or four peer-reviewed publications or book chapters per year in his tenure here. He was a co-investigator on about 12 different research grants, and he also was responsible for doing the mental health training of law enforcement in our state for many years. A very prolific career. In addition to that, just an amazing person. He loved to teach. He really loved to help individuals with mental health disabilities with their legal issues and criminal issues. And I can say he was an incredibly generous person with his time. How many of us did he help put our wills together, get our real estate in order, and with many various legal issues. I don't know if he helped anyone with a divorce or not, but he really did. He really did help a lot of our faculty whenever he could, and our staff as well. So he was very beloved, and he would be so honored to know that that Professor Emeritus Michael Perlin is his guest lecturer for today at this memorial. He raved about him and his career and admired him, for years. So now to our guest speaker who came in from Trenton, New Jersey last night. We're honored to have you here. He is a professor emeritus at New York Law School and founding director of the International Mental Disability Law Reform Project at the Justice Action Center. He's also co-founder of the Mental Disability Law and Policy Associates. You may have seen in his bio, he's heavily engaged in social justice and has been his entire career. He has an extraordinarily prolific career in mental disability law reform, having written 31 books, over 300 articles, many of which deal with the overlap between mental disability law and criminal law and procedure. 7-volume treatise on mental disability law, civil and criminal, which has been universally used as the text on this subject. He's also won several awards for his books as the best book published ever in the year. But on a personal note, I just had the pleasure of meeting him in person for the first time last night, and I just wanted to say a few words. First of all, he has a long history with our department. He's known Dr. Ira Packer, Dr. Grisso, and many other faculty for over 20 years. Second, he's the most popular speaker I think I brought in here. I think Karen can attest to that, with many requests to come to Grand Rounds to see him and to meet with him. And lastly, he's very cool.
Thank you, Gina.
You're welcome. 90% of his publications have Bob Dylan song labels in their title, which he will tell you about. And so without further ado, I'd like to hand the floor over to Michael. Thank you.
That was lovely. Thanks for saying that. Okay. Gina, thank you so much for that really overwhelming introduction. I knew Al, and we used to see each other at conferences, and we would usually sit next to each other. There was always a group doing a jam. Joel Dvoskin played guitar. Bill Foote sometimes played guitar, Matt Zajac, a couple of other people. And every once in a while, I would blow a lyric. I mean, that does happen. And Al would correct me. So that's kind of my strongest memory. But we also talked about law and psychiatry issues all the time. And he was so wonderful. And his memory is a blessing to all of us who knew him. And I'm honored, to be here and participate in this. And thank you all for having me. I do appreciate it. I'm talking today about autism and the criminal law, why therapeutic jurisprudence matters. That's my disclosure, you need to know that. Tell you a little bit about me. Some of you I saw in the last session, so some of you know this already. I was a public defender in Trenton, New Jersey for 3 years. I spent 8 years as director of New Jersey's Division of Mental Health Advocacy. I taught for 30 years plus at New York Law School. I run Mental Disability Law and Policy Associates, which is kind of a mom and pop group that I do with my close colleague, Heather Ellis Cucolo. And I do a lot of stuff besides that. I have traveled every continent except for Antarctica doing advocacy work. I did international human rights work for a good part of my career. I'm a very, very lucky guy is all I can say. So why am I talking about this? Well, autism becomes more important every year in the criminal justice practice. And I get emails from practitioners all over the country saying, what do I do? I've got this client with autism, but I don't know anything about it. And I think it's important, I don't know how many lawyers are in the room. I know most of you are psychiatrists and psychologists, but I think this is so important to anybody who is involved in the legal system in which this may raise. I've done an online course on this topic, and I'll talk about that later, and I've presented webinars multiple times. I've also written 2 recent articles, one with Heather, and again, as Gina points out, I do use Dylan titles. Something's happening here, but you don't know what it is. I'm not singing it, and I'll never get reimbursed if I sing it. How jurors misconstrue autism in the criminal trial process. And the second piece, which I did with Heather and Debbie Dorfman, I saw guns and sharp swords in the hands of young children, why mental health courts for juveniles with autism spectrum disorder and fetal alcohol spectrum disorder are needed. And that, I said, it was in press when I did these PowerPoints a couple of weeks ago. It was published on Monday. So it's available now, thank you, for anybody who is interested. So what's my roadmap here? How do we define autism? And for this audience, that's very, very brief because you guys know about that. The connection between autism and criminal justice, pre-trial. What happens when the jury is being selected? And I mentioned this in the last presentation I did. The great irony that there's jury selection going on now in a New York courtroom. And apparently, according to my Facebook feed this morning, Trump was grousing. He thought he should have unlimited jury, able to challenge jurors. He doesn't understand why in federal court in New York it's only 10. But I'm not going to comment on that. But the voir dire process, deciding who can sit on a jury and who cannot, is in many ways the most important aspect of any criminal case. And it's something I want to talk about. I'll talk about a trial, the role of experts after the trial sentencing, segue a little bit to talk about mental health courts, which I am a big fan of. I've been very, very involved in their creation. I think it's a very, very important thing to think about, especially with people with this sort of disorder. Then I'll talk about therapeutic jurisprudence. So in the last 50 years, autism spectrum has gone from a very narrowly defined, apparently rare disorder to a well-publicized, advocated, and researched lifelong condition. I learned about autism when I was at the beginning of my mental health advocacy years, which would have been 74, 75, 76. And I was working with a local guy who headed an advocacy group, and he wanted a Bill of Rights to be written for people with autism. And I was happy to do that. I said, well, we need somebody to introduce it into the state legislature. And I said, well, how about Senator Menza, he became a judge later, but he was a great state senator. He was always on top of all these issues. And the guy said, no, I don't want Menza. Listen to this. He's the captive of the retardates. He had been doing work for groups involved, which was then called mental retardation, now intellectual disabilities. And he did not want his group to be associated with someone who was associated with that. And in terms of throwaway lines, that's as important as anything I've ever had in all the years I've been working on this. We know that what ASD comes from. We know that it ranges from mild to significant. The numbers of diagnoses in the last, there's a typo here. It's 120. I'm certain, no, it's not a typo. Beg your pardon. It's increased 123% since 2002. And so much of that is now, we are aware of it. There's a slight uptick because people over 40 are having more children, are more likely to have children, and it is more likely in that cohort. But that in no way accounts for this huge change of, and you know, when I started as a rookie public defender in 1971, we knew nothing about it at all. I cannot remember a single client in the 3 years that I was a PD in which someone said, oh, he's autistic. It just simply never happened. This is probably old business to all of you, but the question is, how do jurors interpret it? Especially thinking about some of the aspects of autism, the restricted repetitive behaviors, behavioral rigidity, unusual sensory reactivity. The jury is looking at the defendant and they are judging the defendant, and they are judging him by what they know, which is a TV movie or a story they saw on Action News or one relative. It is the N of one disaster magnified thousands of times. And people, as we know, with autism very often have real difficulties with social communication, sustained social interactions, poor eye contact. Eye contact is so important. President Eisenhower once said something about, I know a person is trustworthy if I can look him in the eye, you know, and that was in 1952 or 56, but that just sort of jumped forever. And people still believe that. And we know that people with autism very often have real difficulty in maintaining social relationships. How about race? How about ethnicity? This is very important. It's very, very disunderstood. Minority children are less likely to have this diagnosis, African-American and Hispanic children both. And the ones who are also generally diagnosed with having intellectual impairments. And there's all these issues about cultural differences. Who goes for services? Who has the money to seek out experts? I mean, this is not news to anybody, but it is important to anybody who is representing somebody with this condition in the criminal justice process. There's also all sorts of issues of self-stigma and shame. And I write about stigma a lot. Later on, I'm going to be talking about saneism, which is a word I didn't invent, but I sort of popularized in the legal literature, and how important that is for people with autism. Well, this makes it so much harder for somebody with these conditions when their fate is to be decided by jurors who either have no familiarity or familiarity is based on a television stereotype, and they consider demeanor evidence. I can look at him and know if he is telling the truth. I cannot tell you how many times I heard that in my years as a trial lawyer, you know, and that's extraordinarily important. What does that mean? Does he react like I would react or my loved ones would react? And this is under the radar. When Heather and I wrote our first article on autism a couple of years ago, I was stunned by how little there was in the legal literature. I mean, there was a lot of stuff in the behavioral literature, a lot of stuff in the psychology literature, psychiatry literature, but the legal literature was utterly bereft. So, what about the criminal justice system? Well, I love to do this kind of research. The first time you see the word autism in a court case was in 1943. It was a libel case. I mean, it has nothing at all to do with what we're talking about, but I thought it was interesting. A magazine article about a doctor who criticized radio serials for their impact on listeners and said they caused autism, which he defined as daydreaming in listeners. I mean, the case was dismissed, but see, first time you see it mentioned anywhere. The first time there was any relevant mention was in an unsuccessful insanity case where the witness's report said his schizophrenia was characterized by marked autism. The witness never defined or explained what autism was. And the only mention before, in an law review article before I started practicing law in 1971, Yeah, I am that old. Was a 1950 article, but I know all these songs. Was a 1950 article about Soviet psychiatric reports that said experts were advised to avoid using terms like autistic. But nothing at all about anything you and I are interested in. It simply did not exist. And how it's processed in the criminal justice system is still largely under the radar. And the estimate is that there are 4 factors that predispose people with ASD to commit or being charged with committing crimes: social naivete, aggression triggered by disrupted routines, aggression due to social misunderstandings, and obsessive behavior with a lack of understanding of the implications of that behavior. And we know that individuals in this cohort are going to be disproportionately charged with some criminal offenses. Computer offenses, sexual offenses, especially when they are related to the computer, stalking offenses, arson, and dishonesty offenses. And these are usually marked by inability to apprehend verbal and nonverbal cues. Disproportionately charged, convicted with non-contact sex offenses, and autistic youth face a much higher risk from online child pornography. Why is that? Well, we know that children with autism are typically several years, I have 5 years, SB, you'll correct me if I'm wrong on that, 5 years behind their peers in sexual development and social emotional maturity. And computers are a window into the sexual world. And as people try to learn about sex, people turn to computers, not just people with autism, everybody. You know, my wife and I are thankful that, you know, when our kids were born, the internet had not been born yet. And I should say, apropos of my children, SB, who is in the audience, was at my daughter's wedding, and Debbie Dorfman, who just walked in, was at my daughter's bat mitzvah. So, I mean, what kind of a combination is that? Hi, Debbie. So what about voir dire? I mean, what is there about voir dire? It's French, of course, for to speak the truth, and it's how we question jurors in a prospective pool to determine by either the lawyer or the judge to determine their suitability for jury service. In some jurisdictions, the lawyer does it directly. In New Jersey, where I practice criminal law, the lawyer can't do it, the judge. The lawyer gives the judge a list of questions. He or she, I say he or she, I never appeared before a female judge in the early 1970s. He or she will answer some of the questions and not others. But the idea is the answers you get to these are supposed to give you some insights. And they also, there's a voir dire to questioning witnesses to determine their competence to testify. Those of you who are expert witnesses, and I know there are several in the room, are going to be voir dired before you can testify so that you are accepted as an expert. So voir dire, you know, what are their background? What are the backgrounds of the prospective jurors? What are their experiences? What are their opinions? What are their beliefs? What are their values? This is all so important, and there is virtually nothing in the legal literature about this. If I am a rookie public defender and I want to learn about this, there ain't that much out there for me to read. This is actually one of the takeaways from my talk. How little there is, so much stuff is overwritten to a fare thee well. This is dramatically underwritten. And voir dire also is used to educate jurors about a mental disability that's suffered by a defendant. And it exposes the jurors it gives the lawyer an opportunity to kind of do a test run on the case. Because if you're saying something during voir dire and you see jurors cringe, you might say, time to try something else. There has to be great care. One of the most important things here is remorse and empathy. We believe, again, we know what remorse looks like. We believe we know what empathy looks like. We also know that people with autism do not have give the same cues as to remorse and empathy as others do. And they give what's a false ordinary common sense. I write about ordinary common sense a lot in my writings. It's I see it this way, therefore everybody sees it this way. I see it this way, therefore it is. And it's used all of the time. So we have this false ordinary common sense about what the juror is. You have to be extremely careful, especially during this voir dire process. And I think it's also important to explore jurors' attitudes towards all mental disabilities. Mental illness, intellectual disability etc. And frankly, you can use this to educate jurors. Some judges won't let you, but if you can, give it a shot. And how the disability affects not just his behavior in terms of what the alleged crime was, but his appearance. Is he not looking as if he's watching the lawyer? Is he staring at the wall? Any of those things? I mean, so much stuff. But the attorney has to, and this is really, I think, to drum into lawyers' heads, the attorney must have a current assessment of the defendant's intellectual level, how cognitive functioning might impair the ability to understand right from wrong. And when I lectured before this to the psych residents, and I was talking about the McNaughton test and the right from wrong insanity defense test, this goes way beyond that. The number of insanity defenses are, this many, but it's still very important for jurors to understand the defendant's ability to understand right from wrong in the same way or in a different way than the juror might. Again, the judge has to look out for ordinary common sense. I spoke about this already. And the judge has to make clear to the jury that their OCS, their ordinary common sense, is wrong, that it's based on media stereotypes or the heuristic of one person they may know. It cannot guide their behavior. And this is something I've written about in many, many articles. And the article that I quote here is from one that I did about the impact of PTSD on criminal sentencing, how that changed after the promulgation of DSM-5. I cite some of my pieces here, and if anybody wants any of them later, give me your card, happy to send anything. Eighth Circuit, in a relatively recent case, 5 years ago, it rejected the defendant's argument in a death penalty case that the trial judge should have asked the jurors more targeted questions about their attitudes towards mental health defenses. And it said, we're not persuaded, said the court, that all mental health evidence carries the same stigma as the insanity defense. These questions adequately were inquired as to bias. There was not a single reference to case law or a reference to anything in the psychology or the psychiatry literature, any of the behavioral literature. It's just what the Eighth Circuit chose to say. The Supreme Court, interestingly, sometimes the Supreme Court does get it right, understands how jurors' perceptions of remorse may be very important. A case called Riggins versus Nevada from 1992, the court held that a competent insanity pleader had a qualified right to refuse medication at trial. As one of the witnesses said, this medication is making him like a zombie. So he would sit there and stare straight ahead, completely blankly, and the jurors expected some kind of physical response, especially if he was innocent in being charged with that, but he was just absolutely flat out. And Justice Kennedy, in his opinion, said, assessments of character and remorse, a very interesting duality there, may carry great weight and perhaps be determinative of whether the offender lives or dies. Again, the population that we're talking about here, people with autism, is perceived as lacking in empathy, lacking in remorse, and this is especially problematic in the court, where the jurors will hone in on demeanor evidence to determine credibility. In the case that I cite here, I'll come back to later, State v. Burr, is not a new case. I mean, 17 years old. The defendant had offered, and the trial judge rejected. It was eventually reversed. When it says affirmed is modified, it was the reversal that was affirmed, where the defendant had offered testimony to assist the jury in understanding why he might act in a way that appears socially unacceptable to others. And that was such an important case. Again, the judge has to explain to the jury why their ordinary common sense is all wrong, that it's premised on media stereotypes, again, or the heuristic of one person that they may know. Counsel should establish their observations regarding the opinions of prospective jurors who may be unwilling to consider these issues during jury selection. And this might prove beneficial on appeal, since every criminal defense lawyer who is worth his or her weight has to understand there's a very, very good chance your client's going to be convicted, and you have to start setting up the appeal before the first day of trial, from the day of the first motion, the day of the first pretrial. Because appellate courts generally defer to trial judges on voir dire issues, but the more that the defense counsel can do ahead of that, the more likely a good outcome is. And the judge has to talk to the jury about the possibility of using stereotypical biases. That happens very, very rarely. It has to include about the impact of autism on the defendant's demeanor, what the juror's preconceptions of what remorse and empathy, quote, look like. And that very often will not comport with reality. Judges, again, have limited understanding and familiarity with autism, and they rely on their own ordinary common sense. So there is a tremendous amount of work that lawyers here, especially lawyers working with expert witnesses, must do in any case. 30 years ago, I wrote this article about the federal sentencing guidelines, and I think it still holds. In attitudes that strikingly mirror attitudes of jurors in mental disability and death penalty cases, judges conceptualize mental disability as an all or nothing absolute construct. How many times have you said to me, Mr. Perlin, is he crazy or is he not crazy? Again, like I said earlier, are you a Knicks fan or a Celtics fan? It's purely dyadic. There is no middle ground. A showing of, and no matter what the issue is, you have to be as, quote, crazy as if you were pleading an insanity defense for mental disability to have any value at all to most judges. And sanest myths continue to be repeated about mentally disabled criminal defendants. And judges engage in what I call pretextual decision-making. Well, Dr. So-and-so, aren't you really trying to say to me that, fill in the blanks of what the judge wants to hear. A colleague of ours was almost held in contempt. Tom, this is about Norm Poitras, was almost held in contempt in Alabama for not saying to the judge what the judge wanted to hear. Now, what's interesting is, there'd been a very interesting article several years ago, and these are all fake jurors, read a vignette about somebody. Half were told he had autism, the other half did not. But those who learned about autism resulted in fewer guilty verdicts and more lenient sentencing because they were given real information. And this article in a journal, which I was only familiar with because I found the article, is a very, very valuable article for anybody doing this sort of work. What about experts? There's two expert cases that are important. Ake v. Oklahoma, and I am very proud. I filed an amicus brief in this case on defendant's behalf, and Justice Marshall actually took a couple of sentences from our brief in the opinion, which is so cool, right? Said that a trial is unfair unless if the state goes against an indigent defendant without access to the raw materials he needs, and that includes using an expert. And in McWilliams, the court expanded on that, saying he had a right to an expert to translate data, medical records, other doctors' reports, into a legal strategy. So, the question is, to what extent is this honored in the breach? Does this really happen? In many jurisdictions, no, it does not happen. As I said in the earlier presentation, call it anything you want, there is a huge difference between blue states and red states here, primarily because blue states generally have excellent statewide public defender offices. And there are still many red states in which there is no public defender. The judge simply goes down he walks into the courtroom, he sees a few people, say, okay, you're representing this guy, you're representing that guy, you're representing that guy, without knowing if these people have ever done a criminal case in their life. And when my students say, oh, Professor Perlin, how many years ago was this? I say, last week, so that's there. But you have to assist the fact finder in understanding complex knowledge. This is all very, very difficult. And it's not going to be within the court's expertise, and it is certainly not within the juror's expertise. The attorney has to sort of learn, what kinds of questions could I ask? I cite here Colleen Berryessa, who I still have never met in person. She's a young woman who is a criminology professor at Rutgers, and she does tremendous work in this area. I recommend everything she's ever done. Judges and jurors don't have the capacity to do this. You need expert insights. And as I said this in the last thing, when you have an expert, typically we'll hire Ira Packer to represent the defendant, to work with it. I'm sorry, to work as a good Freudian slip, right? To work with the lawyer who is representing the defendant to explain to the juror his findings and what he thinks. But I think this needs more than, no offense, Ira, just Ira doing that. I think this needs somebody else, maybe Gina, I don't know, who can explain to the court what all this stuff about autism is. In other words, two experts, one who interviews defendant X and one who talks about it. And I have written about this in an article that is on Lexis. There are some articles that are on Lexis, not Westlaw, some vice versa, in the Arizona Journal of Law and Social Justice, in which I say I believe in certain criminal cases there should be two different experts used, and this is one of those. The expert has to communicate. They have to let the jury better understand, especially because you're talking about different degrees of blameworthiness. One size does not fit all. That's the most important thing that I have to say. And if you can accept that, if the courts can accept that, so much would be improved forever. Back to Burr. Burr is charged. He was Asperger's, which was in the literature then, second-degree aggravated assault. The appellate division reversed because inexplicably the trial judge refused the defendant's request to present expert testimony about what an Asperger's diagnosis meant. This is one of those that had me as a lawyer just hitting my head. Luckily, New Jersey, most judges in the appellate division and Supreme Court are quite good. But again, one of the questions is, say this happened in Oklahoma, where I had a mini career 30 years ago as an expert witness in death penalty cases on lawyers who, if I believed in the death penalty, should have been shot, you know? This luckily, the Burr was in New Jersey and the case was eventually reversed. What about after the trial? What impact is there in sentencing on all of this? And I've got a couple of cases here, and if anyone's interested, I'm happy to send them copies of the slides, or perhaps somebody from here could do that. In one of them, in Zook, Zook was charged with possession of child pornography. He was sentenced to 26 months, and the Fourth Circuit vacated, saying it wasn't enough. It didn't promote respect for the law. It didn't provide just punishment. So sending a young guy to federal prison for over 2 years was considered not enough of a punishment. It doesn't send a message of deterrence, you know, as if people with autism are sitting around at autism meetings and saying, oh, look what Zook got. So we can do that and only go 2 years in state prison. You know, believe that, and, you know, the Knicks are going to play me instead of Julius Randle on Friday. You know, that was a basketball analogy for those of you who don't know. Now, this should not leave you with the feeling that the only thing that matters here is the trial stage. Autism is important on questions of competency. The case that was discussed in the presentation I did to the psychiatry group involved a woman with autism. That was just one of many problems she had. And the question was she competent to stand trial? But you never hear autism discussed in competency cases and responsibility cases. In sentencing cases, it comes up, but it's always after the fact. So courts should not shy away from hearing testimony on the subject. Courts have one rule: move the case, move the case, get it done faster, get it done faster. That's the most important thing. The administrative office of the courts has a list in almost every jurisdiction of how many cases a judge has on his or her trial list and how long it takes him or her to get through them. And more testimony on more expert issues, witness issues, takes longer. So there's always bias about that, no matter what the other politics are. Barbara Doyle, in her piece from Autism Speaks, which is an autism advocacy agency, says, this diagnosis is as relevant to police and legal proceedings as a diagnosis of MR, that's when it was written, or MI would be, no matter how bright, high-functioning, or verbal the individual may be. Because there, of course, are people with autism who are very high-functioning, who are very verbal, who have gone to law school, who've gone, I read something on my Facebook feed the other day about a doctor with autism who came out as a person with autism within the last week or so. It was a fascinating, fascinating piece. But what about mental health courts? And again, Debbie, I mentioned earlier that our article was just published. Debbie is one of my two co-authors on that. I think mental health courts have the potential to be one of the most significant available reforms of the criminal justice system, to divert people from the system into treatment. They're based on team approaches. Justice and treatment agency representatives assist the judge to screen offenders. Do they present a significant risk of violence if released? Can we devise a treatment plan? Can we supervise and monitor the person in treatment? The judge is part of a team. A lot of judges don't say, I'm going to be on any team. I'm the judge. I don't want to hear from team. This only works if there is an authentically formulated team that formulates a treatment plan, a court monitor, a case manager. The participant has to report back to court all the time. That's another reason they don't like it. It's too many cases. If mental health courts are to work effectively, the judge has to develop enhanced interpersonal skills, which is not a sine qua non for being a judge under any circumstances, and aware of a variety of psychological techniques to help him persuade the individual to accept treatment and motivate him to participate effectively in it. Judges have to be able to build trust, convey empathy. The best example is Judge Ginger Warner Wren in Broward County. It's very interesting. I've known Judge Wren now for over 30 years. She made a cold call to me one day. She said, Professor Perlin, hi, I don't know you. I've just been appointed to be the first mental health court judge in the world. I want it in the country. I want this to exemplify both due process and therapeutic jurisprudence. I said, Judge, you've come to the right person. And I know that Ira told me that he has been in mental health court doing these kinds of cases with Gina or with Tom. And yeah, and that's just terrific. And the people here are so lucky for that to have happened. And when you read the report, the self-reports of Judge Wren's litigants, the levels of coercion are so low as to be almost unmeasurable. And that's really, really important. I think it's a model for all new and existing mental health courts. So, are they suitable for persons with autism? It's only mentioned in the legal literature once until Debbie and Heather and I did this article. It was a book review about a book by Lawrence Dubin and Emily Horowitz, neither of whom I know, that said a mental health court specifically created to understand the relationship between the neurological component of ASD with the crime is greatly needed. Education and therapy will make recidivism an unlikely outcome. One juvenile mental health court that I know of in Santa Clara, California, specifically does accept juveniles with autism, but it's the only one I have found. And again, in this article, I said, well, it's no longer forthcoming, it's been published. We argue there should be separate, discrete mental health courts for juveniles with autism and those with fetal alcohol syndrome. So what about therapeutic jurisprudence? This is my money shot. I never do a talk without talking about it. I believe that turning to TJ, looking at dignity, looking at voice, looking at validation, looking at voluntariness, gives lawyers and judicial officers and expert witnesses an opportunity to remediate the full range of issues in these cases. This was created by Professor David Wexler and the late Professor Bruce Winnick that said case law and legislation have therapeutic, and also what lawyers do in court and what court officers do in court, have therapeutic or anti-therapeutic consequences. Should they be reshaped to enhance their therapeutic potential and not subordinate due process? Amy Reiner, as I've said this before, I like mnemonics of the 3 V's: voice, validity, validation, and voluntariness, and I think that's good to remember for it to work. It supports an ethic of care. It tries to bring around health, healing, and wellness. It values psychological health. Valuing psychological health is nothing you read about much in criminal trial practice manuals, nor when I've been on an adjunct faculty member in many med schools, nor have I seen it as something that expert witnesses need to know about. And it's especially important for individuals with autism because their behavior or the way they project themselves may be so radically misconstrued by the fact finders. And first, look at dignity. I mean, dignity and adequate counsel, dignity and compassion. Those are the 3 things that are the most important. That people have an intrinsic worth that should be recognized and respected. And what are some of the maladaptive responses? Well, people get angry, they avoid, they hide. Therapeutic jurisprudence highlights individuals' worth. It's not only necessary by American constitutional norms, we were talking about international human rights law last night, it's required by international human rights law. It creates a feeling of connectedness. It diminishes shame and humiliation. I'm on I'm with a group which is called the sort of Shame and Humiliation Network, which is absolutely fascinating, and it goes to enhance dignity. And I'm one of the very few lawyers on it, but it's the kind of thing we need to do more. We infantilize people with autism, we know that, and it robs them of this dignity. And it's also important that the perception of getting a fair hearing is therapeutic, because it contributes to a person's sense of dignity that he or she is being taken seriously. Hey, Debbie, this is one of the articles you wrote with me with Kerry. I didn't even notice that. And compassion, the psychology of compassion, concern for the suffering of others. This has to be part of the court system. And it's funny, I don't know if those of you who were at my former presentation today, we were talking about Australia. Professor Hopkins and Bartels are both Australian law professors. There's been so much written about this in the Australian and the New Zealand literature, far more in a lot of ways than in the US. Of humiliation, shaming, contravene basic fundamental rights, lead to recidivism, inhibit rehabilitation, and contravene the guiding principles of TJ on the issue of dignity. It also roots out trauma. I did a piece with two forensic psychologists, Julie Goldenson from Canada and Stan Brodsky from Alabama recently, that talks about how TJ can root out trauma, and people with trauma-related mental disabilities, they will feel less coerced by their involvement in the legal process. And this article is basically about how traumatic the examination, when a forensic mental health examiner evaluates a person, how that can be traumatic. One of the, we were talking last night about comments on articles. One of the comments on this article in PPP notes, that's ridiculous. They're just examining them. How could that possibly be traumatic to anybody? Which I hit my head about 10 times. What about sanism? I mentioned this before. Racism, sexism, homophobia, ethnic bigotry, it's kind of the same thing. But it's even worse in some ways because it is so largely socially acceptable. It's based on stereotype, on myth, on superstition, on de-individualization. It affects every aspect of the criminal process, and it affects every aspect of the psychiatric hospitalization process. I think if we use TJ to expose pretextuality, to strip bare the law saying its facade, it will uproot the we-they distinction that has traditionally plagued and stigmatized people with mental disabilities. So, I'm almost done. Good, I wanted to finish at 12:45, I may make it. People with autism are another vulnerable population. The disposition of their cases is at the mercy and competence of attorneys, experts, judges, and juries, none of whom understand what's going on, and outdated court procedures. To uphold constitutional rights, to uphold human rights, we have to be vigilant in confronting ignorance, confronting bias, and what I call misguided pop culture beliefs. We've made such advancements in understanding mental illness and cognitive disability. They're limited, but there've still been great advancements. We have to do the same thing about autism. We have to educate court personnel on how to legally and therapeutically assist people with autism in the criminal process. My colleague Heather and I have taped a 10-week course on autism in the criminal law, in which we discuss what I just gave a few seconds to today: police arrests, confessions, incompetency, people with autism as victims, people with autism as witnesses, expert testimony, juror, etc. And anyone who's interested, Patty Zapp at Concept at Palo Alto University can give you much more information. And that's it. Thank you very much.
Yes, thank you, Michael. So I will be passing the mic around if anyone in the room has questions. That was terrific. Yeah.
Thank you so much for that wonderful presentation.
Thanks.
It's fantastic. Early on in your talk, you mentioned that Hispanics and Blacks are underdiagnosed. And what you have presented is so valuable, and there's such a need for this kind of work. My question to you is, has anybody written about, or have you had experience working with an adult, let's say who is Black, because they're underdiagnosed, that people suspected had autism, but they didn't have a formal diagnosis, and how was that dealt with in court?
Unfortunately, when I was a public defender, autism did not exist in the law and the literature. There is no question in my mind I represented that person, but I did not have a clue as to what was really going on or what to do. I expect now in those jurisdictions like New York City, where the legal aid office has terrific training, etc., people are getting it. But again, and I said this in the earlier presentation as well, we cannot extrapolate from what we know about public defenders in New York, New Jersey, Massachusetts, etc., Connecticut, and extend that to other people, other places. I have been in psychiatric hospitals all over the country. I have seen people who clearly, to me, as a non-medical person, had autism somewhere on the spectrum, and they were just treated like everybody else. And again, the chances are very, very likely they did not have qualified counsel to represent them.
Yeah.
So I didn't, again, I know, there's no question in my mind, I faced it. But this is, I stopped being a public defender in 1974. I stopped being a mental health advocate in 1982. At that point in time, it just wasn't there. So I can't help on that. It grieves me. No question about it. But there was just nothing in the literature at the time. Sure. Other questions? Yeah.
You have one on Zoom?
Judges who work in mental health courts required to take or at least offer training on mental health, intellectual disability, and autism spectrum disorder so that they can be more informed in general, rather than relying just on the expert witness to inform them?
Absolutely not. There may be some states that require it on a state-by-state level, but there is no national requirement for that. Who becomes these judges? And there's really a couple. It's dyadic. It's probably the dyadic, but the important categories are dyadic. You've got some judges who really want to do this, who really care, like Judge Wren, to whom this is really important, and they go out of their way to learn. You have other judges who are appointed to these courts because it's punishment, because they're seen as big judges, and they can't do that much harm in this position. I was telling the last group, there's all sorts of problem-solving courts besides drug courts and mental health courts. There's prostitution courts, sex trafficking courts. There's also a lot of veterans courts. And Julie Baldwin, who's really an expert on veterans courts, did a talk a couple years ago, in which she talked about one judge who wore his camel robe to sit on the bench, because he was a veteran and that's what he did. Another one told a defendant that unless he recited the Pledge to Allegiance standing ramrod straight 5 times, he would not sit on his case. See, right, you've got stuff like that. The mental health court judges that I have observed, it's cherry picked. I go to see good judges in good jurisdictions, and that's great. But again, what I have found is in Australia and New Zealand, by and large, the judges are much better. And one of the reasons is that the proceeding is much better is that you have a lot of the jurisdictions in the US. And in some cases, the mental health court judges aren't very good. Leah Johnston and a colleague did a paper, a law review article that showed that people in Erie County, and I don't remember if it was Pennsylvania, New York, I think Pennsylvania, who went to mental health court wound up spending longer in prison than those who turned it down. My son is a public defender, as I said, and when he was in New Jersey, he would tell his clients not to go to drug court. I said, why? He said, well, because anyone who went to drug court in his county would be sentenced, the suspended sentence would be the max for the charge. So it'd be like 15 years in prison. And if they failed one P test, and surprise, everybody who's a heroin addict fails at least one P test, they go to prison for 15 years. Whereas he could have gotten a sentence of 3 months if he avoided drug. So what's a poor boy to do? That's right. Before I get to your question, one of the other issues is the prosecutor. There are prosecutors that I have seen that try to kibosh the effectiveness of problem-solving courts. And when that happens, they don't work. And that's problematic because you need the head prosecutor to step in And since in most jurisdictions, not New Jersey, mercifully, they're elected, they're not going to do that because they don't want to be on the wrong side of Action News. Yeah.
So with regard to the last comment that you made, one of the issues we confront.
We hear you.
Okay.
You're okay.
One of the issues that we confront is the perhaps apparent lack of education of the counsel who represents somebody with a mental health condition and advocates for appropriate increasingly adversarial for us. So, not appreciating that somebody is in an acute episode of mania and their behavior may have led to some behavioral discontrol and a crime, but they want them out now without an adequate period of treatment. That would be a just rough example. So one of the concerns that we have is it's not just judges that require some level of education, and it's not just autism. We're concerned that counsel doesn't appreciate or is not adequately educated about mental illness writ large.
It seems to me that goes into. First of all, I agree with you totally. Counsel is generally not educated about mental illness at large. And when I was teaching, I spent times flying across the country, speaking to public defender legal aid offices about that. And you're right. But on the other hand, there's something I think that's very, very important that may cut against what you're saying. Everybody who is in danger of being committed to a psychiatric hospital has an absolute right to a hearing to resist that. The courts have said that uniformly, that if somebody is going to be locked up against their will, they have a right to vigorous counsel. In reality, most counsel is not vigorous. Mostly everything just kind of gets rubber stamped. One of the difficult issues is with this person in question has a criminal charge. There may be two different lawyers, one representing him or her on the commitment, retention, release hearing, and the other representing him or her on the criminal matter. And that can get very, very dicey. What you need there is cooperation between the public defender's office or whatever it is, the legal aid office, and the mental health advocacy office. That happens in some jurisdictions, not in others. But the person in question has an absolute right to counsel to vigorously defend them. And the answer is, if the state, if the prosecutor or whatever, the county counsel, whoever the person is, attorney general, does their job and shows by a preponderance of evidence or clear and convincing evidence, it is in most jurisdictions, that the person is mentally ill and likely to be dangerous to self or others, then the person's going to be committed. But that does not obviate their right to a vigorous counsel.
Another question online. This is from an expert. And when it says, when he's been involved in evaluating offenders with autism spectrum disorder, the question is often asked whether I can recommend an
There is some advocacy, but it has not gotten very much off the ground. Debbie, you know about this better than I do. I mean, I have seen some pilot projects, but I've not seen anything on a real global level.
I'm Executive Director of Disability Rights.
Here you are.
I'm the Executive Director of Disability Rights Connecticut, their sister agency's Disability Law Center here in Massachusetts. You probably know them. And so we struggle all the time with individuals who have autism trying to get services. And actually I have a case right now of a person who shouldn't have probably been prosecuted in the first place, but now stuck in a forensic mental health facility, not getting the appropriate treatment. So now the challenge is finding is this very issue.
And so it is there are really significant systemic issues that need to be addressed. And so one of the problems is the lack of there's something called the autism waiver, which is a federal federally funded services for people with autism, but the number of slots is so small that we have like, I don't know, maybe a 15-year waiting list. So there has to be, there, I think, are some good ADA, Olmstead types of arguments and other maybe Medicaid advocacy that can be done. And, I think the protection and advocacy systems throughout the country are thinking about these issues. I know we certainly are. And there's other issues which have to do with rates that the state pays for Medicaid providers. So that's part of the problem that you're talking about, or the gentleman's talking about, is that the rate of pay to serve folks is so low. In Connecticut, it's much lower than Massachusetts. And so, of course, people are more likely to come to Massachusetts to provide the service than they are in Connecticut, because why would they stay in Connecticut if it's so much lower? So there's all these issues, and I'm sorry, I don't mean to take up too much time, but there's, but the advocates, with whom I'm working in our community and I know around the country are thinking about these issues. We do litigate these issues, but it is hard and it really requires systemic changes, I think, proactively before folks even make it to the criminal justice system, because once they get in, the school districts, if they're younger folks, don't want to deal with it. And even if they have a responsibility, it makes it harder to get a community provider. But folks can be served in the community with the appropriate services and supports. Just need to get the slots, need to get the rates up, and those kinds of systemic things. So anyways, sorry for the long answer.
No, Debbie, thank you. And let me just pick up on one thing you said. Debbie sort of slid over a little bit the ADA, the Americans with Disabilities Act. And last month, Debbie and I and two others did a talk at the Academy of Criminal Justice Sciences on the ADA of criminal justice and mental disability. And one of the issues is the ADA applies, other than to federal prisons, the ADA applies to everything, pretrial, trial, where one is institutionalized afterwards. And very, very few lawyers ever think about that, because public defenders represent criminal defendants. People who do the kind of work that I used to do in mental health advocacy represent people on whether they should be in or out of a hospital. The ADA is something very different. And I that's something that all of us need to work on more. People I've talked to, expert witnesses, say, what do I care about that? It's a federal statute. It doesn't affect me. It does. It affects every single person on whose case you're sitting. And I think that's so important. Thank you so much for raising that.
Other questions? I have two very quick questions. The first is to Dr. Daly. Do we have a juvenile mental health court in Massachusetts yet?
We don't running. We're getting close.
Okay.
We have 16, I think it's 16 or 18 mental health.
16 mental health courts?
Yeah.
Oh, a lot more than I thought. 16. Okay.
That's a lot more than many states that have 10
That's a
times
lot.
your population.
And the second question is, you cited a lot of research. Is it of autism in the criminal law? Was there a mix there of research that was done on the juvenile side versus the adult side, or is it primarily adult?
Primarily adult. There is very, very little research. When Heather and Debbie and I did this article on juvenile mental health courts, we found there was an article that a student at St. Mary Law School in Texas did 20 years ago who recommended these courts for people with fetal alcohol syndrome. But we found absolutely nothing for people recommending it in the past literature. We're the first ones.
Okay, great.
Okay.
Thank you very much, Mike. Thank you, everybody.
Thank you all very much.